nullification is the most important constitutional remedy Americans have to runaway centralization, the most important. Yet there is much confusion about it. I debated state nullification with Alan Guelzo at the University of Virginia a few years ago, and he argued that state nullification is unconstitutional, leads to anarchy, is treasonous, and led to the Civil War. The reason for such a deep division is that we have all inherited two incompatible views of the Constitution, which I shall symbolize as Jeffersonian and Lincolnian. Both were intimated at the founding, and they have never ceased to perplex us. The conflict turns on where sovereignty is vested. For the Jeffersonians, it is vested in the people of the several states. To say a state is sovereign is to say it can govern itself without permission of any other state. These sovereign states created by compact an artificial corporation called the United States as a service agency to which they delegated what Madison said were, quote, a few well-defined powers, end quote. These were mainly defense, foreign treaties, and rules for interstate commerce. All of the powers are reserved to the people of the sovereign states. Consequently, and this is important, those powers are undefined and unenumerated in the Constitution. Only the states have the authority to know what they are. In short, if a power is not delegated to the central government, it does not exist. And if a power is not prohibited to the states by the compact, it exists, whatever it is. Since a state is a sovereign political society and a party to the compact, it has the constitutional authority to nullify any act of the central government that intrudes into its reserved, undefined, and unenumerated powers. The Lincolnian vision of the Constitution flatly denies all of this. It holds that the states are not and never were sovereign political societies. Sovereignty, they say, is vested in the American people in the aggregate, a national will. This sovereign American people ratified the Constitution, and in doing so, created the states as artificial corporations for administering the national will. Lincoln actually compared the states to counties. They're like counties. If an American state is essentially a county, then Lincoln is absolutely right. It cannot lawfully nullify an act of the central government any more than a county can nullify lawfully an act of the legislature, because the county is a creature of the legislature. Now so which one of these is true? There is no space here to defend the Jeffersonian understanding of the Constitution. I will simply say that the historical evidence of how the Constitution was formed and ratified provides overwhelming support for the Jeffersonian view that the Constitution is a compact between sovereign states delegating only enumerated powers to the central government. However, from the first, there were those who wanted a nationalist constitution with the central government having plenary power over individuals in the states. Alexander Hamilton, whom we might say was a proto-Lincolnian, described the Constitution as a, quote, frail and worthless fabric, end quote. It was frail and worthless because it acknowledged the sovereignty of the states. From Hamilton to Lincoln and beyond, the goal of nationalists has been to twist interpretation of the Constitution so as to weaken the power of the states. In this, they had only marginal success until Lincoln's decision to invade and conquer the southern states. The Union victory transplanted to America the French revolutionary idea that, like France, America the American people in the aggregate are sovereign, and that the states are the mere counties Lincoln said they were. This French view is reinforced today every time we say the Pledge of Allegiance to a flag symbolizing, quote, one nation indivisible, end quote. And by the way, that pledge was not officially approved by Congress in 1942, and we didn't even get a national anthem until 1937. So it took some time for this Lincolnian thing to sink in. Although this Lincolnian understanding dominates, it has not subverted the founding Jeffersonian view, which is deeply planted in the constitutional DNA of all Americans. This means most Americans suffer from a kind of constitutional schizophrenia. I know I'm a recovering schizophrenic. I mean, I grew up with this. Now, the schizophrenia is this. A Lincolnian Constitution is incoherently mapped on to a Jeffersonian document to which it is allergic. What is called the Civil War was in fact America's French Revolution, which crushed a federation of states into a would-be unitary state. Now, had Lincoln and the Republicans been honest, because remember that was a revolution, had they been honest, like the French revolutionaries, they would have destroyed the Jeffersonian Constitution and written a new one, making clear that the Constitution is not a compact between sovereign states. And if they had done that, you and I would not even be talking about state nullification today. We would know that the central government has plenary power. But they were not honest. They did not write a new constitution. Rather, they corruptly interpreted the Jeffersonian document as if it were the constitution of a unitary state. But it is not. No honest mind can fail to see that it is, if you read all four corners of the document, that it is a compact between sovereign states reserving all powers to themselves except for the few delegated to the central government. That is precisely why Hamilton said it was a frail and worthless fabric. He was honest. He looked at it and he said, this is crap. Lincoln looked at it and said, it's a nationalist document, and hoped nobody would notice. The nationalist reading of the Constitution at each step in its history, from Judge Joseph Story, Daniel Webster, Abraham Lincoln, to the 20th century Supreme Court, has been based on fraudulent interpretations and on violence. How many times have you heard it said that the Civil War settled the question of state nullification and secession? But it did not, precisely because the document ratified by the states in 1787 and amended in 1791 was not destroyed. Should have been, if you're going to have a revolution, but it wasn't. Nor did the Reconstruction amendments alter its Jeffersonian character. These amendments abolished slavery, gave black males the right to vote, and imposed new restrictions on the states. But these amendments did not alter the character of the states as sovereign political societies, nor did they alter the character of the Constitution as a compact between those societies. This muddled Lincolnian view that the states are not sovereign political societies and the Constitution is not a compact has dominated from 1865 until today. But with the peaceful dissolution of the Soviet Union, by the secession of 15 states in 1991, and a number of peaceful secessions in Europe, since then, as well as devolution movements, the Lincolnian vision no longer commands the unthinking allegiance it once did. It's not credible. The 10th Amendment Center spontaneously arose to keep tabs on the many nullification movements actually going on in the states today. Shows the Jeffersonian vision has, these are vital signs. Even secession is again topical in America. in a way in which it was not when I was coming along. A public policy poll, for example, found in 2012 that 25% of Americans would like to see their state secede. That is 80 million people. They all said a pledge of allegiance to a nation, one and indivisible. Among those identified as very conservative, it was 37%. And here's something really interesting. A public policy poll in 2015 found that 37% of millennials favored secession of Texas, and 42% of those millennials favored secession of Britain from the EU. Now, these millennials are going to rule the country one day. Well, you know, yes. But prior to the Lincolnian Revolution, the right of state nullification was used from 1787 to 1861 to keep the central government in check. This is Clyde's point that it has always worked when tried. Consider a few examples. In 1792, only a year after ratification of the Bill of Rights, this is very early, Jefferson explained to Madison the basic outline of lawful constitutional state nullification. The issue was whether the central government had authority to charter a national bank. Now, the Constitutional Convention at Philadelphia had raised just that question and by a large majority refused the central government to charter any corporations. That was to be reserved to the states. Yet Hamilton persuaded Washington and Congress to charter a national bank. Jefferson resigned his position as Secretary of State in disgust and went into opposition. He explained to Madison how the Virginia legislature could nevertheless block building a branch of the national bank in Virginia. Okay, you could have a national bank, but we won't have a branch in Virginia. The legislature, he said, should reason as follows, quote, and here's the first outline, I think, of the classical argument. Quote, the power of erecting banks and corporations was not given to the general government. It remains, therefore, with the state itself. For any person to recognize a foreign legislature, in this case, Congress would be the foreign legislature, to recognize a foreign legislature in a case belonging to the state itself is an act of treason against the state. And anyone acting under the authority of a foreign legislature, whether by signing notes, issuing or passing them, acting as director, cashier, or any other office relating to it, shall be adjudged guilty of high treason and suffer death accordingly, end quote. So that brings you up short, doesn't it? I mean, only a year later, in Georgia, the Supreme Court took its first bold step of usurping state sovereignty. They couldn't wait, and was happily blocked by an act of state nullification. The case was Chisholm versus Georgia, 1793. The plaintiff held a bond issued by Georgia before the Revolution, which the state declined to honor. Georgia refused to appear before the Supreme Court on grounds of international law, that being a sovereign state, it could not be sued by an individual without its consent. Georgia being absent, the court ruled in favor of the plaintiff. In response, the Georgia legislature declared the ruling unconstitutional, null, and void. Step beyond its power, its authority. Its House of Representatives passed a resolution stating that any federal agent who entered the state to enforce the ruling would be, quote, guilty of felony and shall suffer death without benefit of clergy by being hanged, end quote. Now, I think today we would give benefit of clergy, but I mean, you get the point. Georgia sent its ruling to other states which agreed, and they quickly passed the 11th Amendment, which affirmed what, except for federal arrogance, needed no affirmation, that American states are sovereign political societies and cannot be sued by individuals without their consent. Had Georgia not nullified this lawless act of the Supreme Court to protect its citizens, Chisholm versus Georgia would have stood as a precedent for more centralization. They put up a shield to protect their citizens from this arrogant act of the Supreme Court. 5 years after this episode, Jefferson wrote 2 Kentucky resolutions, 1798 and 1799, and Madison wrote the Virginia resolutions, 1798, and the Virginia Report, 1800. These 4 documents are the classic statement of the constitutionality of state nullification. We should have them in a little book. Again, these Virginia resolutions were sent, they nullified the Alien and Sedition Acts. I forgot to mention that. That's what it was about. They were sent to the states. Some were opposed, some didn't even reply. So Virginia decided not to enforce the nullification. Instead, Jefferson ran for president on a platform of state sovereignty, was elected, and freed those imprisoned under the invalid law or invalid act. There's no such thing as an invalid law. The Kentucky and Virginia resolutions came to be known as the, quote, Principles of 98. And Jefferson's election to the presidency was known as the, quote, Revolution of 1800. It was a revolution because it reasserted state sovereignty. From then until 1861, the Principles of 98 were invoked in every section of the Union, North and South, to protect the citizens of the several states from tyrannical acts of the central government. And by the way, perhaps we should revive that term. Instead of talking about nullification, we should talk about the Principles of 98. We should have bumper stickers, the Principles of 98, because this is part of our history, and we can tap into that. The public knowledge that the states could nullify acts of the central government had a chilling effect on the arrogance of central power and kept it in check. During this period, up to 1861, Americans arguably enjoyed more individual and political liberty than any people in the world before or since. There's white Americans, the Indians and the Africans were not quite considered part of the polity, but for those who were, they had more liberty, I think, than anybody then or since. New England states nullified Jefferson's embargo, Madison's War of 1812, the annexation of Texas, and the fugitive slave laws. Wisconsin nullified the fugitive slave laws. It is said that South Carolina's nullification of the tariff abominations in 1832 failed, but it did not fail. It is true Andrew Jackson rattled sabers, but calmer heads prevailed, Congress rescinded the tariff as demanded, and South Carolina repealed its nullification. The result was that the Union was made a stronger and happier place than before. Gentlemen understood each other. They had to behave. State nullification is not something peculiar to the American system. In some form or other, it is essential to any large federation that is serious about preserving the political liberty of its federal units. The UN Security Council gives member states a veto. The European Union allows various ways of opting out of certain policies. Once free of Northern domination, Southerners instituted forms of state nullification in the Confederate Constitution. Among these was that it allowed impeachment in the National Senate of any federal official operating in a state's territory if supported by 2/3 of the state. So any federal agent had to be careful, the state could impeach him. Tell that to the IRS. They would have to make it. Or federal judges. And more important, think what you could do with federal judges there. And more important, it required only the Confederacy required only 3 states to initiate amendments and force a vote on them. If this ordinance were in play today, the people of the sovereign states, not the Supreme Court, would be deciding issues regarding the place of religion in society, abortion, so-called gay marriage, and so on. As it is, the people have no say on these and 100 other matters over which the Supreme Court has arbitrarily claimed jurisdiction through unrestrained Alice in Wonderland readings of the 14th Amendment. A final example is the Canadian Constitution for nullification. It allows any province to nullify any federal law in the area of civil rights. If this rule were in place, an American state could opt out of civil rights legislation regarding abortion, school prayer, gay marriage, law enforcement, and the like. I should add that the Canadian Constitution also provides for a conditional right of secession. Not so in Lincolnian America. Quebec in 1995 voted not to secede by 1%. How Canada gained these rights is an interesting story for us, especially for Southerners. Judah Benjamin, Secretary of State of the Confederacy, fled to Britain after the war and became a famous barrister. He's still well liked in Britain. He won a number of cases for the Canadian provinces, and by doing so incorporated the principles of 98 into Canadian case law. When Canada gains its independence in 1982, state nullification in the area of civil rights was included in its constitution. John Stewart, a Canadian senator, once told me there's a saying in Canada that having lost the war, the South having lost the war in America, won it in Canada, where we talk about nullification and secession as policy options. Not so in Lincolnian America. But there is a practical problem. Although state nullification is undeniably one of the checks to federal tyranny in the Constitution, no constitutional rule has been worked out to define a valid case of nullification, as exists in the Canadian and Confederate constitutions. In our system, as Jefferson said, each state must decide for itself the nature of the infraction and the remedy. If other states do not accept the nullification, a single state might find it practically impossible or at least difficult to enforce it. So this is a problem. To remedy this, the Constitution be amended perhaps to include a rule that defines a valid state nullification. It is unlikely this will ever happen with Congress. Congress is not going to be interested in doing this. The states will have to jump over, they will have to get 2/3 of the states to approve, calling a convention to consider this, and that has never been done. That's a high bar. So the states are practically rendered silent on initiating constitutional amendments. Theoretically, yes, but practically, no. And of course, one problem with getting an amendment is that people have been taught for over 100 years that nullification is unconstitutional, and legislators are so tied to federal money and the benefits of federal regulation that they don't have the civic virtue, and there's not the civic virtue in the states to do some of the things they should do to protect their citizens. Madison said the state legislators have a, quote, duty to erect a shield to protect their citizens from unconstitutional acts. They have a duty. Well, what can we do? The first thing is to revive the notion of state sovereignty by constitutional education, as we're trying to do today, by celebrating state identity and history, and most importantly, by political action. How often do we read in history books that Jackson, Lincoln, the Roosevelts, Nixon, and others each greatly increased the powers of the presidency? You've heard that, right? Oh, they increased how do you do that? Increase the powers of the presidency. And how much we read that the Supreme Court expanded its power through landmark decisions, or how Congress expanded its powers during the Reconstruction period. Why is it that only the central government expands its powers? Why don't the states expand theirs? And all of these powers was expanded by bold political action to which the states and other branches acquiesced. To regain the powers of sovereignty, the states must do the same thing. That is, they must, through bold but prudent political action, break out of the bounds within which a usurping central government has confined them. This requires civic virtue, patience, and prudence, knowing when to act and when to pull back. It should begin with matters that are easy to win, even if they're small. One gains strength, confidence, and understanding through the exercise of state interposition. Now, a single state could start the process. Consider the case of California. The federal government outlawed medical marijuana. California refused to comply. The matter went to the Supreme Court, which upheld the law and ordered California to comply. California ignored both Congress and the Supreme Court. Without the cooperation of state authorities, the federal government did not have the officers sufficient to enforce the order, nor did it have the will in this case. Pot wasn't that bad for the central government. So the central government backed down. The Supreme Court had egg on its face, Congress had egg on its face, and they backed down. This display of weakness emboldened 16 other states to pass legislation allowing medical marijuana. Weak. It's weak. We can do it. And that exercise of state sovereignty in turn inspired 4 states to take the even bolder step of legalizing recreational marijuana, for which people are sitting in jail today. And they got away with it because the central government couldn't do anything about it. In short, and the central government has nuclear weapons, it has tanks, it has everything, but power is based on opinion as much as it is force. In short, the states pushed back, and in this case, the central government backed down, yet it refuses to recognize these acts of state nullification. And it enforces its law where it can. So the central government controls interstate commerce, so you can't use a credit card to buy pot. You have to use cash within the border of the states. Now, to some, this conflict between state and federal law is very disconcerting and irrational, but it is not. Such constitutional conflicts are supposed to happen in a federal system of sovereign states the size of a continent comprising 320 million people. This is what you should expect to happen. It's called democracy and government of the people. Constitutional conflicts of this sort enable Americans to see when one-size-fits-all federal laws do not actually fit. How would you know they don't fit unless such action is taken? And it enables Americans to recall what had been forgotten, namely that the states are not counties to be played with by the agencies of the central government, like a medical quack practicing with a hapless patient, but are real political societies that have flesh and blood and can and should be able to beat to different drums. The case of California and the sister states that joined her in resisting congressional marijuana laws and the Supreme Court's ruling illustrates how state nullification can work today, even in Lincolnian America, where nullification is theoretically said by some to be anarchy and treason. Despite the federal government's stubborn attempt to hold on to its marijuana law, most people today, whether they like marijuana laws or not, most people today believe that the regulation of marijuana is now a matter for the states. Most people believe that. Why do they believe that? They believe it not because Congress or the Supreme Court authorized the judgment, but because a small number of sovereign states authorized the judgment. That's where the authority is. And what worked for regulating marijuana, given the right political climate, not the wrong political climate, but the right political climate, and the right state leaders, not the wrong ones, what worked for marijuana can work for recalling state regulation of abortion, school prayer, education, marriage, law enforcement, and 100 other reserved powers the central government has usurped from the states. Now, one habit that must be broken is the unthinking ritual of going to the Supreme Court to resolve every constitutional dispute. We need to have something like AA for people to go to get. I don't think you'll ever get over. You could be a recovering legislator on this matter. Wherever the Supreme Court has clearly usurped the reserved powers of the states, the court must be told in no uncertain terms that its ruling is null and void. It is not anarchy or even civil disobedience to refuse obedience to an act of the central government that is not a law. Nullification is not civil disobedience. It is a kind, but it's claiming that what you've done is not a law, has no authority. You've gone past your limit. And nowhere does the Constitution give the Supreme Court the final say on what acts of the central of government are constitutional. If you believe it does, just float an amendment to the Constitution saying that the Supreme Court has final say on this and see if it passes. Would never get out of Congress. One fear is that, and I'm about to finish now, one fear is that reviving state nullification would lead to a number of constitutional crises. It would. And that is a good thing. There are deep disagreements that have long been suppressed by runaway centralization. This generates an unhealthy condition of smoldering resentment that could erupt into violence under right conditions. Nullification allows these resentments to be brought out in the open and critically discussed. Another concern is that a federation of 50 states comprising 320 million people is simply too large and unwieldy for public debate on the nullifications and the proposed constitutional amendments that will inevitably arise. Just too big. Moreover, the cultural and other differences between the people of the several states, when once brought to the surface, might reveal such a depth of disagreement that constitutional amendments simply could not resolve them because of the sheer scale of the polity. Now, these are valid concerns. However, they are not caused by nullification, but by a United States that has grown too large in population and centralization for the purposes of self-government. The United States central government is like a 600-pound man who can no longer play sports, dance, or even enjoy a walk because of his sheer disgusting bulk. The U.S. suffers from bulimia or obesity. Now, this was the judgment of George Kennan. I don't make, George, I have to have authorities. George Kennan, who some say is the conscience of America, and he's one of the great foreign policy thinkers. He invented the containment policy of for the Soviet Union. He wrote in 1993, 2 years after 15 states peacefully seceded from the Soviet Union, that America also needed to begin a process of secession. Okay. Like the Soviet Union, the American Union, he argued, has grown too large and unwieldy for the purposes of self-government, and he said we should begin a debate on how to divide it. Now, secession and division are remedies used today in Europe to counter over-centralization. Britain recently seceded from the EU, and Scotland may well secede from Britain to join the EU. Secession is also a lawful instrument available to American states as conceived in the Jeffersonian tradition. And indeed, a negotiated division of the United States, as George Kennan proposed, might well be a reality down the road in America's future. But nullification is not secession. It was designed not to divide the Union, but to keep it together, while at the same time not suffocating the political liberty of the states in exercising their reserved powers. These powers have been progressively hollowed out by the Lincolnian Revolution of 1861-65. Thank you. Now,